New REIQ contracts, what real estate agents need to know to succeed. If you're a real estate agent in Queensland, you'll know the REIQ contract of sale is the backbone of almost every property transaction. Recently, on the 1st of August 2025, the REIQ rolled out new editions of both the house and residential land contract and the community title scheme contracts. Here's a breakdown of the 9 key updates you need to understand so you can guide your clients confidently to avoid any nasty surprises at settlement. Kicking off in number 1, combined contracts. The new REIQ contracts, first edition, combine the residential house and land contract and the community title scheme contract into one new contract. This means no longer do you need to pick the correct contract type for the property that you're selling. They're now all located in one convenient contract. That's why, guys, it's super important to use this new first edition and not older editions. Number 2, new disclosure obligations. The most significant shift is around seller disclosure. Sellers must now provide a Form 2 seller's disclosure statement before the buyer signs the contract. If you haven't heard this by now, then you've been living under a rock. We've been talking about it for months. For agents, this means you'll need to factor in extra time before a contract is signed, budget about a week. If you do this at the Form 6 appointment stage, you'll be ready when the property hits the market, should an early buyer come along. It's critical to ensure the disclosure statement is complete and accurate, otherwise the buyer will have a right to terminate. And supporting searches like contaminated land, easements, etc. are essential to be provided alongside the disclosure. Remember, our firm can take care of all of this for you. All you need to do is introduce them to us and we'll take care of the rest. It's all on our website. And in position number 3, tenancy schedule. The new contracts have amended the way we deal with tenancies. Tenant details are now to be attached and not included in the contract body. This is an annexure with information such as the names of the tenants, the terms and options, including start date, end date, bond, rental amount. Also, the details of the rental manager are required, including the property manager, agency, contact details, address, etc. Make sure that's filled out. The contract on page 4 still obliges the vendor to advise if the property is subject to a residential tenancy agreement or rooming accommodation agreement at any time within the last 12 months before the contract date. If so, vendor must advise the day of the last rent increase for each residential premises. If you want a copy of the tenancy schedule annexure, we've got that available in the blog. You can download it as a PDF. Next, GST and land tax clauses. The contracts place stronger emphasis on sellers seeking tax advice before signing. You should have been instructed in your Form 6 as to which option is correct given the circumstances that apply to the vendor. If you're unsure, always ensure the client gets that information from their accountant. We can't give tax advice, real estate agents, you can't give tax advice, as we're not qualified to do so. Note that either the GST or land tax sections, if they're left blank, there is a default option that will apply. Always check with the client and get their instructions, don't guess. You do not want the seller turning around pointing the finger at you if there's a problem. Number 5, pool safety. New pool safety laws. If a property is being sold in Queensland with a pool and they have given the buyer a pool safety certificate that was current at the time it was given, for example, at the time the seller's disclosure was given to the buyer, the seller is not required to provide a further pool safety certificate, even if it expires during the contract period. If no pool safety certificate is given, then a Form 32 notice of no pool safety must be provided prior to the buyer entering into the contract. And number 6, guys, new extension right. A new standard clause, 6.3, has been introduced for late unsigning of documents, which could complicate matters if the other side's conveyancer is inexperienced. If a party in a PEXA workspace is unsigned between 3 and 4 p.m. and does not re-sign before 4 p.m, the matter is automatically extended to the following business day. Keep in mind, this clause can only be used once, so if it happens again on the same contract, it is invalid. Number 7, new standard clause, inspection of body corporate records. You will see a new clause for the inspection of body corporate records. If a time frame is filled in, the buyer has a right to inspect the body corporate records. If they're not satisfied with their findings, they can terminate the contract. They must give written reasons to the seller without delay if they do terminate and the seller requests more information as to why the buyer terminated. The buyer must also take all reasonable steps to inspect the body corporate records. Number 8, body corporate information, statutory warranties and contractual rights. Controversial topic, guys. Prior to these new contracts, you may have been able to get away with writing refer to disclosure statement for some or all of these questions. You can't do that anymore because there is no disclosure statement for body corporate matters. It's now called a body corporate certificate. Writing refer to disclosure statement will not fly because this information is not in the body corporate certificate or the new Form 2 disclosures. So how do you find the answers? Great question. Ideally, ask your client. If they don't know, then they can discuss with their body corporate or otherwise an additional search through a body corporate search agent, which may find the correct information for compliant disclosures. And in position number 9, place for settlement updated with new REIQ contracts. So now the place for settlement section depends on whether the seller has a solicitor. If the seller's solicitor has an office in Queensland, the settlement takes place in the city or town where that office is located. If the seller doesn't have a solicitor or their solicitor is not based in Queensland, the default settlement will be Brisbane CBD. The place for settlement section matters because if electronic settlement isn't possible for some reason, the place for settlement is what decides the fallback location for a paper settlement. Wrapping it all up. The new REIQ contracts are designed to increase transparency and certainty, but they also introduce new traps for the unwary. As the first point of contact for most buyers and sellers, you real estate agents play a key role in ensuring contracts are compliant, accurate, and enforceable. At Empire Legal, we've already been working with the new contracts, new forms, and of course the biggest shake-up of them all, the new disclosure obligations. If you want to take the legal load off your plate, Empire Legal is here to help. We want to work alongside high-performing real estate agents to enhance your client's experience and have a smooth sale all the way to settlement. What you want when you're picking a provider to work with is a trusted choice. If you're thinking about engaging someone else, just Google them, read their reviews. That'll be the true test, what the public says about that company. All the information you need to get started is on our website. Check out our Instagram, and if we look like a good fit for your brand, all you need to do is refer us to your clients and we'll take care of the rest. Thanks, guys, and we'll see you next week. Ladies and gentlemen, please keep in mind that all advice is general in nature and does not constitute legal advice. This is authorised by George Souris, Empire Legal, Gold Coast, Queensland, Australia.